Good afternoon, everyone. I don't know how many people are online yet, so I'm waiting a minute or so just to ensure people have logged in. I'll begin. Good afternoon, everyone. My name's Jeremy Phillips, KC in Francis Taylor Building, having around 1,000 years or so been a solicitor in my own law firm, then ended up various teams in a couple of national practices. My aim is to take you through a quick 45-minute dash of statutory nuisance whilst you're all enjoying your lunches. And I'll leave 10 or 15 minutes or so at the end for your questions, which I hope is okay. So you'll see on the slide, I've listed 7 broad areas that I intend to cover. First is what statutory nuisance is, and various sources of law that we rely on when considering it. Secondly, the duties and powers of local authorities, including particularly concerning noise nuisances. Thirdly, I'll talk a bit about drafting an abatement notice, then moving on to the next question of appeals against notices, and then fifthly, enforcement of a notice, including criminal offences and the various offences that arise, including BPM. An ultimate topic will be statutory nuisance proceedings brought by a private individual, which my experience seems to be an increasing number at the moment. And then lastly, a favourite topic close to my heart, which is the mediation of statutory nuisance appeals. Before I move on, I should perhaps just explain that the idea for this talk came to me following a series of dinners where I became aware that statutory nuisance is increasingly an issue for local authorities and obviously for people affected, which is developers and operators. And I think that's probably because with the housing crisis that we're presently in, and the questions of availability of land and possibly slightly less expensive land, residential housing is increasingly encroaching upon existing businesses, both manufacturing and retail, and also infrastructure. And it's where you get that interaction that you get complaints that give rise to these challenges. So that's where we are, and certainly it seems that many people have wanted me to talk about it today. So the relevant legislation, it's conveniently set out principally in the Environmental Protection Act of 1990, and also it's all principally set out in Part 3 of that, and also Schedule 3. And there are other areas which I'll talk about in due course concerning liability of companies, and also the issue of service, which falls under Section 160. And then, in addition to that, you need to be aware of the Statutory Nuisance Appeals Regulations of 1995, which are again extremely helpful in setting out the grounds of appeals and the process to be followed by the courts. I would just say in passing, I don't think I cover it elsewhere, that in my experience, magistrates' courts do not love statutory nuisance appeals because they even find it difficult, again, in my experience of working out whether these are really criminal proceedings or civil proceedings and so forth. So it's when you get to the magistrates' court, if you're unfortunate enough to do so, you can expect some fun and games, particularly the DJs who the cases tend to be assigned to. So moving forward, before one reaches for the Environmental Protection Act in Part 3, you need to be aware, as of course I'm sure the majority of you are, of the various other regimes that bear on nuisance generally. So I've just listed a number there. You've got public nuisance and private nuisance common law. An example I've given there is political demonstrations, which cannot be a statutory nuisance. The special provision, section 79(6)(a), dealing with that. Particular provisions, specialist provisions of the Environmental Protection Act 1990, for example, those relating to contaminated land, which are dealt with under a separate part, Part 2A. Land which is specifically excluded by Parliament from the scope of statutory nuisance. For example, the issue of artificial light, which is capable of being a statutory nuisance, but not so where it arises in relation to the lighting of airports, harbours, railways, and so forth. In addition to that, you've got other legislation which deals with noise, noise on construction sites, where consents are granted by local authorities under control of the Pollution Act. And also you have the environmental permitting regime managed by the Environment Agency, where permits have been granted for a particular land use. Issues do arise, particularly in relation to enforcement when you're dealing with statutory nuisance. In fact, we'll talk about that in a moment in relation to a particular case. And more. Again, just as an aide-memoire, really, I've listed there a number of additional legislation: the Antisocial Behaviour Crime Policing Act, Clean Air Act, Noise Act, Public Health Act 36, which from memory was quite invoked quite often during the COVID pandemic. TCPA, land which is affected, adversely affected in relation to amenity, Housing Act, Protection from Harassment Act, Building Act, and Refuse Disposal Amenity Act, which affects abandoned vehicles. You just need to check in any particular case whether there is other legislation which might be more usefully deployed. Having done that, I'll move to the specific areas where statutory nuisances arise. There are listed on this, I've listed 5 of the initial provisions. And the first relates to, it can be a statutory nuisance where premises are in a state as to be either prejudicial to health or a nuisance. And where you see on that slide, I've put in as to be, square brackets, etc. That means as to be prejudicial to health or a nuisance. So in other words, all of the categories which I'm listing here, they either have to be prejudicial to health or a nuisance, or alternatively, in some cases, both. So in relation to premises, this is a fairly ancient provision going way back before the 1990 Act, going back into the 19th century, and I've listed a couple of helpful authorities. And it can be particularly of interest to local authorities where you've got supposedly substandard housing stock, which the tenants or local council taxpayers feel strongly about. And so there's quite a case law concerning it. But it has to be, housing has to be in a fairly poor condition for it to amount to a statutory nuisance. And in particular, an example which I cite there, which is arose from the case of Bell and Lambeth, which was a case from I've cited very much in a matter that I was involved in. If you merely have inadequate sound insulation for a property so that you've got external noise, that is not in itself, it does not mean premises are in a state as to be a statutory nuisance. In the case of Palby, which I cite there, which is an 1889 case, what the judge said dealing with that case was it applies to premises, the legislation of that time, and the case law carries on into the 1990 Act, applies to premises that are a danger to life or limb. So as I say, it has to be a very extreme state for it to be covered. The case I was involved in a few years ago now was where a resident of very expensive property, sadly, I think from memory, on almost her first night in it, found the noise from the flat above unbearable. And she had a massive row with that flat and also the service company which was organising the flat, and launched her own Section 82 proceedings. The key issue that the court determined in the end was not whether the building was prima facie constructed in an unsuitable way, but when the person in the flat above had carried out work on the floorboards so as to reduce the sound transmission below. The argument of the claimant in that case was whether they had done it negligently so that the floorboard. And I think the key takeaway from that case was one needs to be very careful if you instruct an expert that they actually know what they're doing, because the expert in that case was not great and had not complied with their duty to the court to be objective and so forth, and got very short shrift from the judge. So that was unhelpful. Ground D, also listed on that slide there, dust, smell, steam, or other effluvia. Again, in my experience, is an increasingly common cause of complaint, particularly from restaurants. Just been dealing with a case where the owners of a restaurant in a particular building found fairly shortly after acquisition that there were complaints from the flats above. More historically, I dealt with a case up in the northeast where a town centre, or city centre in fact, had been plagued by odours from a factory. It was an American operator and they specialised in food flavourings and also perfumes. So the residents of the housing estate to the northeast, where you got the benefit of the southwest prevailing winds, alternately would get smells of curry through their properties one day, and Lenore or other products are available, of course, perfumes, fabric softeners the other day, and so very upsetting. And that was quite a substantial battle, which eventually we resolved in a way that I'll describe in due course. But as I say, in each of those cases, one needs to be able to identify the cause of the nuisance and then to say it's either causing prejudice to health or it is a nuisance. The remaining list, I think F was probably historically of more significance from memory. The very earliest cases on statutory nuisance related to pigs in the sties in city centres, which isn't not a terribly welcome combination. But moving down of those categories, G, I would say noise emitted from premises is probably by far the most common problem that we experience. I'll talk about that in some detail. But for example, the courts consider that in the 68 case of Hampstead and Garden suburban properties and Diomedes, Mr. Justice McGarry, as he then was, he went to the Court of Appeal, when he was resolving a dispute between a restaurant playing music and a nearby house, explained in very clear terms excuse me, where his view of the priorities lay, and saying it is the home rather than the meal table, referring to business and industry, which must prevail. A home in which sleep is possible is a necessity, whereas loud music as an accompaniment is, for those who enjoy it, relatively a luxury. And in a much more recent case, which made the Supreme Court in 2014, Coventry and Lawrence, which is 2014 UKSC 13, that approach was followed, dealing with that and a range of other nuisance issues. And of course, the European Convention on Human Rights, Article 8, right to respect the home, also has a bearing. And when dealing with noise, the critical evidence which one would expect to be given is that from the environmental health officer, because that one doesn't need, if you're a local authority, you don't need to instruct separate experts. If your environmental health officers are prepared to say, this is my profession, I have certain amount of training, and I can say what the members of the committee should reasonably expect, and in my view, this is not acceptable, then the courts will very often accept that, depending on the weight of the evidence and the weight of the evidence against them. So important matters when you're looking at noise are such matters as location, where was the evidence taken? There's a Watney Mann case of 1976, which deals with that in some detail. The WHO guidelines for community noise date back to 1999, but have been reviewed from time to time since then. The noise policy statement for England, and just the quality of the sound, matters such as tone, intermittency, the time of it's occurring, the duration, the season, attenuation background. All of these can be factors which will make the noise in some cases a statutory nuisance, in another case not. And just before I move on from the issue of noise, there's the classic statement, of course, from Justice Thesiger in Sturgis and Bridgman, which was an 1879 Chancery Division case, where Justice Thesiger said, very much anachronistically nowadays, one thing, what would be a nuisance in Belgrave Square would not necessarily be so in Bermondsey. Now, I'd be very careful these days of quoting that. I mean, my younger children is actually moved into Bermondsey, which seems to me quite upmarket, but it's the point that is being made is that statutory nuisance is very much location dependent, and in some areas, industrial areas, manufacturing areas, people moving in might expect a certain amount of more noise than in others. And that's actually not, because it's not, well, it's quite relevant to the issues that we see in central London and parts of the city at the moment, where increasingly people are moving into city centres, not just London, but throughout the country. We're moving back into city centres, and you get then the conflict between the residential expectations and also existing businesses, bars, clubs, nightclubs, and so on, which inevitably generate a certain amount of noise. So that's an area of interaction and potentially conflict. And lastly, quick point I'll mention on that slide before I move on is, of course, the principle of the agent of change, which is now forms part of the National Planning Policy Framework. It's paragraph 200 in the 2024 version, which is simply that if one comes to an area where historically there has been a certain amount of noise. For example, it might be railway sidings or something like that. And then you come and you anticipate problems because you are now in that area, then it's down to the agent of change, the incomer, if you like, to address that issue and to ensure that there's mitigation, rather than simply come in and start complaining about the existing noise, which they would have known about full well when they made the move. So moving on, I just set out in that slide, I won't go through it all in detail, but some of the duties that local authorities are subject to: the duty to inspect, the duty to serve an abatement notice. Ordinarily, there's a duty to serve where you identify a statutory nuisance. If it's a noise nuisance, one has a certain amount of leeway. One can, within 7 days, the statute says, investigate it, see whether it's necessary to serve a notice or whether a modification of the operation might be agreed with the person responsible. But if not, then one has a duty to serve the notice. And again, I'll touch on a case where that was very much an issue. Then section 160 talks about modes of service. They're not mandatory, they're permissive, but it's worthwhile looking at those to see which might be most appropriate. And you need to serve it principally on the person responsible, but in some cases where that cannot be identified, on the person who is the owner of the property. So an abatement notice needs to address the noise concerned, and it needs to require it to be abated and for it not to recur. How that is done is not the responsibility of the local authority. And a particular case where that was considered by Divisional Courts Bud in Colchester Borough Council, which was 1997. Environmental Law Reports, page 128. And in that case, the Divisional Court looked at the question of greyhounds barking in a particular location and said, well, again, it's not down to the local authority to deal with that issue. The owner of the greyhounds could resolve it by getting rid of the greyhounds, or deal with them in a different way, or insulate the property. It doesn't matter. All the local authority had to do was say, stop that barking. Which for somebody who's lived near kennels, I could quite, in the past, quite sympathise with. You also need to identify in the notice the period within which the abatement must take place. And again, I deal with many such cases. I think quite a lot of care needs to be done. And in my experience, that calculation is very often kind of back of an envelope job. Nobody's really thought about it terribly carefully. But I think it's important to do so, because otherwise it's a very easy ground to challenge and you're unnecessarily giving away elements of your notice where you don't need to. So where I'm instructed in these cases, I say, well, look, let's look at it. How long practically do these people need to have to change what they're doing? Do they need to buy new equipment? If so, how long is it going to take them to get that? Do they need to apply for planning permission? In that case, when could they submit it? How long would it be for it to be determined, and so forth? And it's very worthwhile when you make that calculation, keep the documents that show it, so that when it is challenged, or if it's challenged, you can say, well, look, the reason we put 6 months was for this and this and this reason, and we therefore think it was an entirely reasonable period to allow. The notice must also put the recipient on notice that there's a 21-day appeal period, and conveniently people simply attach the relevant extract from the appeal regulations 95, in my experience, to the notice, and that sets out those matters and also the grounds upon which they might appeal. So, appealing against abatement notice, well, I appreciate for those of you from local authorities, I anticipate that's the majority of the people on this particular webinar. It's not your major worry, but anyway, I've just set out there 4 of the 10 grounds which one can appeal the notice on under the 95 regulations. Just to be clear, my advice to the recipients of notices is, unless it's absolutely clear that the abatement notice is going no further, and it's absolutely clear one has a written understanding with the local authority that no further action is going to be taken because they are satisfied that suitable steps have been taken, there is no nuisance, one should always appeal. And I've seen some horrendous cases recently where people took, frankly, a very laid-back approach, and they accepted assurances, which I think were, frankly, wrongly given by officers, saying, well, don't worry about it. Yes, it's a notice, but you know, if you just do this, we're quite relaxed. So it's just, you know, it's just a formality. Obviously, those of you involved with abatement notices would know that's not the best advice. And indeed, if advice is given in those terms, and it leads to a notice being in place and then being prosecuted upon, it could in itself be good grounds for an abusive process argument. So not good practice from either side. In a particular case where that had happened and the client had not appealed the notice, I was frankly horrified that that was the case, because this had the potential to permanently affect the business operation. Fortunately, very fortunately from their point of view, and again, I'll deal with this in due course, the local authority had identified the wrong company as the proper recipient of the notice. And so when we pointed that out, they had to reserve the notice, and then we were able to appeal it properly. Right. So there are 10 grounds of appeal. I've set out the first 4 there. The notice isn't justified. There's no statutory nuisance. Something wrong with the notice. Thirdly, we've offered alternatives and local authorities unreasonably refused to accept it. Fourthly, point I've just dealt with, the time allowed to correct it is not sufficient. Just distracted slightly here. I've got a couple of questions. I'm going to probably, just for continuity, get to the end if that's okay. Sue Brown has asked me to deal with a case where sleep is a necessity, but music is a luxury. In fact, yeah, Sue, I may deal with that offline, but I'll have to look back through the slides. Otherwise, I'll hopelessly overrun and we'll get very cross with me. So just moving forward. The remaining half a dozen grounds, very importantly, the 5th ground there, BPM, best practical means, were used to prevent or counteract the effects of the nuisance. I'll deal with that in some detail shortly. And less commonly, the premises are premises to which the Control of Pollution Act applies, and what the local authority is seeking by way of the Environmental Protection Act is more onerous. And then the last 3 grounds are the abatement notice should have been served on somebody else instead of the person who received it, or it would have been fair, equitable for the notice to be served on somebody else instead of, or it would have been fair for notice to be served on some other person in addition to. I mean, these are all each very fact specific. One has to look carefully at the individual case. Moving on, looking at the time. So the magistrate's court needs to look at the facts at the date the notice was served, and that the case that decided that was a Surrey Free Inns case, SFI Group PLC against Gosport in 1999. And the magistrate's court will look at it de novo, if you like. They won't simply rely on the local authority's findings. Everything is up for grabs. And when hearing determining the case, the magistrate's court has the power. They can quash the notice, they can vary it, but they can only vary it in favour of the applicant, and that's very important. So in other words, they can dilute its impact, but they can't make it any stronger in terms of its effect. Alternatively, they can dismiss the appeal and allow the notice to stand. Alternatively, in some cases, magistrates can make order. This, in my experience, is much rarer, but it can make an order for the works to be carried out by a particular party and who should pay for that. In terms of costs, it's usual where notices are upheld for the local authority to be awarded its costs, including officers' costs. But if it loses, and so it's not an entirely level playing field, and the reason for this is that courts don't want to dissuade local authorities from performing their statutory duties. So local authority won't normally be liable for costs unless they behaved unreasonably or negligently or alternatively in bad faith or dishonestly. There is a right of appeal to the Crown Court, although that's fairly rare, but I certainly have known of that happen. And then there's a further appeal on point of law to the divisional court, and case law again encourages one, if one is going to go to the divisional court and challenge legal points, then one should do it by case stated. In other words, you require the magistrate or the Crown Court alternatively to say, these are the facts I found, this is all the evidence, and then to put a case for the divisional court. Was I right in concluding that ABC? And then the divisional court comes back, and if you're right, if you're fortunate, says yes, it's yes, or sometimes I've certainly seen no, you were wrong, no, you were wrong, no, you were wrong. Decision overturned. So once an abatement notice is in force, because there's been no appeal, or there has been an appeal that's been dismissed, or the notice has been upheld but varied in favour of the applicant, then prosecution can be brought. It can be brought by a local authority, or much less commonly by a member of the public, but it's possible. It's summary proceedings, so it can't go straight to the Crown Court, it's summary only. And the question for the court is, has there been a failure to comply with a valid notice? If so, was that without a reasonable excuse? There are a number of cases on what might not be a reasonable excuse. And if there is no reasonable excuse, does the defendant have another specific defence? In other words, for example, well, I may be technically in breach of the notice, but I have used best practicable means. There's nothing more that I can reasonably do to comply with the notice. If those defences fail, then there's an unlimited fine available, although obviously not normally applied in significant amount in the early days, but can ramp up certainly. And I mentioned there just at the foot of that slide, where the notice applies to a company, then it is possible to include within the proceedings the names of directors, managers, secretaries, or other similar officers. And certainly I've been involved in cases where we've done that because it's become somewhat apparent that the company doesn't really care hugely about it and has maybe significant assets, so forth. But believe me, as soon as you identify directors and name them on the proceedings, that is guaranteed to get attention. So that can be a good tactic if you can identify the fact that the nuisance has arisen due either to their consent, their personal consent, or the statute says, or the connivance, or it was attributable to their neglect on the part of the individual consent. So you have to have some good evidence, but in some cases you will do. And as I say, it's guaranteed to get a very speedy, very often unhappy response. There are alternative remedies. In addition to seeking a conviction and fine, one could go for an injunction. One can take steps and actually do the work on the property and then charge the owner or the operator. And then if necessary, one can charge those expenses on the property itself. So I've said previously that I will talk a little bit about BPM. As I say, it's very often a central feature of the case. In other words, yes, there's a nuisance, but we are a business operation. And the example I gave of the factory up in the northeast, in a city centre, and from memory, they said, well, look, we're providing employment for all these people. We're very successful. We've done everything that we can do to avoid these smells escaping our factory building, the curry one day, the fabric softener the next day. And so there was a lot of expert evidence in that as to whether that was actually correct. And so, I, acting on behalf of the local authority in that case, called experts to do with the pressure, the air pressure maintained within the building, which was had to be a negative pressure, so sucked air in as opposed to allowed to fugitive odours to leave the property. And well, in many cases, I've been involved in rail cases where we talked about rail technology, noise abatement, buffers, screens, sheds, all sorts. You just have to look at the individual case. And again, I'll deal with a specific case study fairly shortly. But it's a very important area. And it's important to understand it is a defence to be raised by the party receiving the notice. However, although operators will generally be in a best position to judge, it's their business and industry, after all, it's not local authorities. You have a whole range of matters that you need to consider. My advice always to local authorities is, well, at least look and consider the question BPM, consider at an early stage what the company, the operator, is saying about it. Because if it's immediately apparent that they have done everything that they could reasonably do, then it's not in the public interest, I don't think, to spend thousands of pounds going to court and simply to require them to prove that if you can easily be satisfied yourself. But it does cover, as I set out there on that slide, best practical means reasonably practical, and it includes a whole range of factors such as what is known in the industry at the moment, technical knowledge, the financial implications, certainly not irrelevant. One looks at design, installation, etc. I'm going to accelerate a little bit because I appreciate we have not a limited time here. And again, I've just set out on that slide, I won't repeat it all, that it is not available for every statutory nuisance. It's principally in relation to industrial, trade or business premises, but it can be available in some domestic circumstances, but very, very limited. And then I deal briefly, largely outside this particular talk, but situation under Control of Pollution Act, other remedies available. And there I list the powers which can be extremely useful when you're investigating whether there is a statutory nuisance: powers of entry, obtaining warrants, removing equipment, opening vehicles, and so forth. And then also, just as a footnote at the bottom there, a reminder, of course, that the Human Rights Act applies, as does the Public Sector Equality Duty, and the duty to make environmental information available to the public. Now, I touch briefly, and given the audience, I won't deal in any very much detail at all with this. This is Section 82 proceedings, and these, in my experience, are invoked really where the local authority is said to the member of the public, look, we're not interested, we do not think that that is a statutory nuisance. You are very unhappy about it. If you want to, you go and sort it out yourself. And again, I dealt with a number of cases where people have done that, and sometimes to good effect if they've got the evidence, but it's extremely difficult for an individual to do that personally, not least of which because of it's technically a criminal prosecution as opposed to the issue of a civil notice like the abatement notice. And therefore, as a prosecutor, you have all the duties of the prosecutor in relation to disclosure of documents, which, again, any of you involved in criminal proceedings will know are extremely detailed and onerous. And those are very difficult for a private individual to comply with. But I've been involved in, say, a number of cases. One particularly in a farming area over on the east of the country, where my client was incredibly annoyed by the use or misuse by farmers of bird scarers, that is, machines which would fire off every, whatever happened to be, minute or two, a loud bang to scare the birds from their crops. But she was a scientist by profession. She travelled all over the world in her particular discipline, and so was more than a match for the farmers. And she went to the NFU. She looked at the NFU guidelines for bird scarers, and she managed to prove that the farmers were using them incorrectly. And in fact, they were simply moving birds from one field to another. And if they wanted to do it properly, they needed to do it in a particular way. So that was interesting. But yeah. So I am now going to, and so on, and that's just consequences where you do pursue Section 82 proceedings. So, practical example. I used this, and I'll cover this. I'll try and do it in about the next 5, 6, 7 minutes, at which point I'll end. Only because it really was the gift that kept giving, I suppose, from the lawyer's point of view involved. But also it had pretty much every aspect of statutory nuisance that one can possibly consider, and I really will race through it. So this is a letter that goes back to 1947, where T.E. Wally Limited, was inappropriately named, got permission to mine a particular area in the centre of Stoke-on-Trent, within Newcastle-under-Lyme Borough Council's jurisdiction. So that was 1947. This is around 2007 when Lafarge got permission to fill in the big hole that had been created over the previous 60 years or so with waste. So this was an application for the environmental permit to the Environmental Agency. Planning permission was also obtained for the site from Staffordshire county council. And as I say, it fell within the jurisdiction of the borough council as far as statutory nuisance is concerned. Now, suffice to say, within a fairly short space of time, complaints arose, and this is just a collage of some of the activists locally who really were very active in very many different ways. And you'll see from this slide, it's like a bad case of the measles. You can see in the center there, there's a blue outline, and the dots are where the complaints arose. And this was a case where the Environment Agency said they had more complaints about this one site than all the other landfills in the country put together. So it really was a significant problem. The local authority canvassed the population, and this is a word cloud of the type of complaints that were forthcoming, literally in their thousands, so causing a huge headache for councillors and then in turn inevitably officers. Now, of course, at the same time, the Environment Agency had granted a permit for the site and was, I think it's fair to say, somewhat defensive about their activities. No, we granted a permit, it's got these conditions, we're on top of it, not a problem, you know. And so they issued initially information leaflets, and subsequently they created websites, and yeah, it was quite a kind of public relations exercise to show that they were doing all they could do. This is the Wallis Quarry itself. You can see in the centre there, yeah, this isn't showing, but you can see in the centre there the landfill, the hole that's being filled, and then around the site, one edge, the westernmost edge, from memory, you had the leachate wells where all the nitrates, phosphates were running off into the water supply and then captured in tanks and tanked away from the site. And then over on the right, you had the gas flares, because of course these sites where you have large amounts of waste, they create significant volumes of methane, which can be sold, but it's extremely destructive. So you have flares burning it off, but it actually damages machines and they need to be carefully maintained and so forth. And then also around near where we see the flares on the eastern side, you can see housing, and housing was increasingly encroaching on the landfill, inevitably causing problems. The borough council actually objected to the county council when it was considering planning permission, said, well, look, if you grant planning for all these houses right all around the site, we are going to get problems, we're going to get massive complaints. And the planners said, as they so often do say in my experience, oh, no, don't worry about that, it's covered by the Environment Agency, they can impose conditions, it won't be a problem. But of course, it absolutely was a huge problem. So I'm afraid they placed far too much faith in environmental conditions. So that was the locality of a different kind of map, and you can see in the blue dots there was where environmental health officers would take samples and test. So they get a call from the householder, we've got a terrible smell, we can't breathe in our house. Very often, by the time they got there, the odour, which was transient, had gone. And we had the somewhat strange situation in this case. I can't remember the number of environmental health officers, but it was in double figures, but very little evidence from any of them that there was actually a problem, which seemed somewhat at odds with the thousands of residents who were saying that there was a huge problem. I won't say much more about that. And then here's some of the data which the Borough Council had to collate. I mean, it was a huge scientific evidence gathering exercise. And in that exercise, one of the things that they did very early on, which was incredibly sensible, was collate all of this data into an online database that could all be filed, identified, located, and so forth. And that was, again, a massively sensible step. So this was the notice which the council served, the abatement notice which it served on the 13th of August 2021, having consulted with me extensively on the exact wording, because it's so important to get it exactly right. So that's a nice little half a page notice. And here is the grounds of appeal drafted by leading counsel elsewhere, 3 pages, which I don't criticise them, and citing pretty much all the grounds. The abatement notice wasn't justified. There were defects and errors in it. Council had unreasonably refused to accept alternative methods. Council had allowed insufficient time to correct. We've used best practical means. And overall, in fact, we think that the council is responsible, not us, and there's no nuisance. So every possible ground you could imagine, they really covered all the bases. So we assembled our army of experts. We had landfill experts, because it's an extremely technical operation to assemble a landfill in terms of how you line it, how you fill it, how you pressure down the materials, how you cover them, how you tap the gas off, how you take the leachates off. So we had landfill experts on the engineering construction side. We had leachate, hydrology experts on the movement of water and leachates and so forth. We even had nose experts. Oh, sorry about that, that's my grandson, I think. But we had other nose experts as well. And you can see the ladies there sitting all around a sniffometer where the sensitivity of their noses to different smells is actually assessed and monitored, and that enables them to give evidence in court proceedings, because you get a readout. We had pollution roses, so that showed the extent of pollution, methane, and the areas in which it was concentrating. That actually is atypical, because normally one sees most pollution occurring on the northeastern side of the location due to the southwesterly prevailing winds. And so we were all set up for a massive battle between good and evil. And I'll leave you to decide who's who. And a 5 or 6 week trial. I'm sure Clarks and Chambers were thinking it was all going to be very good business. But sadly, I spoiled the party, really, because I said, frankly, from day one, that this is all terribly interesting and really, so many interesting points of law and evidence and so forth, but it's a complete waste of time. It is a waste of time. If we could only get everyone around a table on a kind of without prejudice basis, which is what happens with mediation, we can talk confidentially, we can find solutions that everybody's happy with. It'll be informal. It's not binding at all, so that we can have open discussions, because nothing's binding until agreement's reached. And it can include everything. So you're not confined to points of law, or particularly, I've dealt with many mediations where apology is the most important thing. Admission, well, I was wrong, or here's a bunch of flowers, or whatever. It's such a fabulous process that if anybody doesn't already know about mediation and isn't a huge fan, do find out about it, because it is a wonderful process. And probably most important of all, where you need to carry on dealing with each other, as for example in this case the council needed to carry on having a relationship with the Environment Agency, having a relationship particularly with the operators of the site, then it's a brilliant process, because you don't come out with a winner and loser as you do with court and one party bearing massive costs, but you come up with an agreed solution that everybody's bought into and has signed up for. So it is a wonderful process. And that's what happened. So these are the steps in mediation. I'm rushing a little bit now because we only have 5 minutes. You have a proposal, you have an agreement in principle, you select your mediator, an agreement, timetable, position statements, bundles of documents inevitably, meetings with the mediator, and then settlement agreement if it all works. And so in this case, it worked, but what it was better. My expectations were exceeded. We agreed dismissal of the appeal, that notice was upheld. We got a comprehensive agreement on all the technical issues, we sorted out costs, everything was covered, and we ended up with a joint public statement on what was a hugely controversial issue locally. Now, sadly, that wasn't the end of the story, because albeit mediation was hugely successful and avoided a great battle in the magistrates' court, subsequently it transpired that there was still an odour from the landfill site, despite all of the steps that were taken. So, a little point of interest, it was very difficult to find experts. And it is very difficult sometimes in these cases because they have conflict of interest. But I made it my business to identify experts, and I found a fantastic company in Sweden where their English was frankly better than ours. They were very advanced in environmental terms, and they were really superb. So we went through all those steps as indicated on the slide there, and with the company having gone bust in the end. So at least the site has stopped taking landfill, which was a significant part of the problem, and it has been sealed by the Environment Agency. And so all the residents lived happily ever after. So 10 top tips for authorities. I'll go through them very quickly. Always document every interaction. It's very important. You don't want to be relying on conversations. Look carefully at what your EHOs are saying. Sometimes they're fantastic and will be complete winners in court. Sometimes they're less so. Be prepared to identify where your complainants live. Very often people say, oh, I don't really want to get involved and I don't want my name used. Well, unfortunately, if the court is looking at whether there is a nuisance, the court needs to know where the problem is. So you have to give it up. Create an online database. So if you've got large numbers and lots of data, then create a database where everything can be found properly. Get good experts. Make sure that you get the right person to receive the notice. Make sure you've got the right operator or owner, whatever, depending on what the issue is. Be very, very careful drafting the abatement notice, because even commas and full stops and so forth are critical when they're being interpreted. Generally don't say how the abatement is to be, how the nuisance is to be abated. Let the operator do that. Just say, you have to abate it. How you do it, it's down to you. Serve it properly, and do consider mediation. And on that note, I have 2 minutes left. I'm sorry that I haven't left more time. But looking quickly, I've got a note from Yale. Hi, Jeremy. For the local authorities to inspect the area from time to time, how are EHOs required to determine if statutory nuisance exists? Do they need to witness the statutory nuisance from the resident's property? I would say yes, absolutely. And it's very common in my experience for them to go in there and to witness it, whether it's an odour issue, which is more difficult because they're very transient and temporary. For noise, sometimes they set up remote noise monitoring and record it, but they do have to visit. And yes, I've got another one from Sumaya Rawat, I hope I pronounced that correctly, where you've got a recording device. Should the complainant produce a statement in relation to what they did to activate the device? Yes, I would say. You've got a district judge in noise case involving generators installed close to housing. Should we accept steps of defence suggesting, as it is the local authorities' problem, that planning was granted? I would say no. Planning and statutory nuisance are separate issues. It may be that the planners were foolish to grant planning permission, but statutory nuisance is a separate regime. and the fact that council has made one mistake doesn't mean it should compound it by not dealing properly with the statutory nuisance. Alan Evans, we've got an appeal against the abatement notice. Recipient is trying to get us to withdraw the notice. He'll carry out the works, but we're not satisfied the works will abate the nuisance. Do you agree we can't agree to withdraw the notice on that basis? Yes, and in fact, funnily enough, I've just dealt with a case very similar to that in the West Country. And the council required to be absolutely satisfied before it was prepared to withdraw the notice, and it wouldn't do so quite properly until it had good evidence. And then John Stevenson has mentioned the issue of Ripper, which of course is absolutely right when you're looking at remote recordings. So on that basis, I think I'm 1 minute over, so I'm afraid I will wrap up this talk. Disclaimer of everything I've said, of course, it's complete rubbish and I take no responsibility for it at all. But subject to that, that is me. Thank you very much for listening. I hope you have a very nice lunch. I'm extremely jealous. And if you've got any queries, then do let me know. I'm very happy to deal with them. Thank you very much. And goodbye.